Welcome to Georgia Estate Law Explained.
Welcome to the show where we bring clarity to estate and family law practice in Georgia. I'm Sophia Morales, and I'm here with attorney Stephen Scriber, founder of Scriber Law Group. Each episode, Stephen breaks down legal issues that matter to most families, from protecting your legacy to planning for life's transitions. If you've ever wondered where to start or how to make the right legal choices for your family, you are in the right place. And today we're going to dig in trusts versus wills. So welcome back, Stephen. I'm so happy to be discussing this issue.
Awesome. Thank you. Likewise. Great to be here.
So tell us a little bit. Let's start with the fundamentals again. What's the difference between a will and a trust in practical terms?
To clarify kind of definitionally, so a will is a document that is in writing, signed with certain formalities in front of two witnesses and a notary public in Georgia that states what happens to your assets upon your death. So it may be left to a person, it may be left to a trust, but it is a document that is only binding upon the time of your death. So having a will that says I leave everything to Bob and Sally have no rights to that asset until after the person dies, and then after the will is admitted into probate. And a will is Georgia anyway is a document that's also used to nominate conservators for children under the age of 18. So it is, because it does go through court once a will is admitted into probate, then it would also nominate a conservator if, God forbid, someone died with the child under the age of 18. A trust, meanwhile, and I'm going to use a trust, there's a legal term called an inter vivos trust, which just means a trust that you create while you're alive. It's a separate document from a will. So a trust, unlike a will, goes into effect immediately. And you kind of view a trust as kind of a vessel where it allows assets to be, you can put assets into the trust rather, and then the assets are held during the lifetime of the person who creates the trust, typically for the benefit of the trust creator, but it could be for someone else's benefit should they desire. And then upon the death of the person who creates the trust, then those assets are distributed according to whatever directions are in it. So, for example, I create a trust. I create a trust to hold my phone, for example. So I then hand my phone to the trustee, who then holds the phone for the rest of my life for my benefit. And I may even be the trustee of this trust, so I'm holding this phone for my lifetime for my benefit. But then upon my death, this phone then goes to my beneficiary. So my beneficiary could be my children. So my children now get this phone. But my children are 6 and 9. So they're not responsible enough to own this phone. It could be this phone, this house, this insurance policy.
Whatever it is. Yeah, exactly.
And then, so I have language in there. It says their grandparent or a corporate fiduciary like a bank is now in charge of holding this phone until they turn 25. And so when they turn 25, they get whatever is in that account. Provided that until they turn 25, the trustee can pay for their bills. So if they're used to going to summer camp every year, the trust would pay for that. If they go to college, the trust would pay for that. If they want a car, the trustee would pay for that. Knowing my preferences that I want them to drive a used Honda and not a new BMW.
Right.
As a former driver of a 1985 Nissan Sentra, I can say I wouldn't want teenagers to have a brand new BMW because they are not great with money or cars. So you can have lots of provisions like that. Or if you're having a second marriage, for example, like say you got married, your first spouse passes or you get divorced, and then you remarry. So you might have your trust now designed to say, if I die, the trustee holds this asset for the benefit of my surviving spouse. They pay my surviving spouse's bills to the extent that I supported them. until the end of their lives. And then whatever is in that trust account then goes back to my children. So it
Right.
never passes into the state of my second spouse, where it would then
Right.
go to their children, which would what in that scenario, I imagine that their first spouse would be rolling in their grave or haunting. But so you can have a lot more sophistication in there, and you can also add things like Medicaid protection, special needs trust provisions if you have someone who is unable to work or is otherwise incapacitated. You can have a lot of things in your trust, and I
Yeah.
may have over answered your question, but the trust is a living document that you can work with right away. It has a lot more power and provisions on it. Whereas a
Yeah.
will is a document that you have to kind of wait till you die to be able to actually use it fully.
Yeah.
But obviously you should
Exactly.
have it, but you should it's not one that it's not nearly as powerful a document.
Yeah, I was going to say it doesn't seem like you can do as granular a thing with it as you can with a trust.
Not the same way. In some ways, you can create a trust in your will, but that trust obviously doesn't come into effect until after your death. So to get to that more granularity, but I think most people who want the granularity are gonna prefer having a separate trust.
Yeah.
And if they're like me,
I,
they talk to a lawyer. We love granularity because we want
eh,
everyone to be precise in what they want to do and how they do it. And some
mhm.
people want to say like, hey, just throw the whole thing at them when they turn 18. Great. If you're happy with that, that's a great plan for you if that suits your family. And other people are like, they're not very good with money, but I want to support them. So I want it to pay their bills until it runs out. Otherwise, he will gamble it away or something.
Yeah, exactly. I was going to ask, are there specific scenarios where one is clearly more beneficial than the other?
So, yes. So having a trust is very advantageous when you have young children. So because you want to make sure that anything you leave them, especially if you have insurance policy or things you want to leave for their benefit, are held in trust until they are an age where you would feel comfortable with them receiving it. Um, it's a trust is advantageous in situations where someone might be on Medicaid, and Medicaid doesn't distinguish between Medicaid and Medicare. Briefly, Medicare is what everyone who turns 65 can enroll onto. It is not means tested. It pays for medical care, like your average routine, going to the doctor, getting surgery, most types of prescriptions with the prescription plan. Whereas Medicaid is a means tested program. It's typically for people who don't have assets. So the infuriating thing about American setup as far as our healthcare goes is that Medicare, the one that everyone automatically enrolls onto, does not pay for nursing home care and does
Yes.
not pay for long-term care. So if you have like a full-time home aide or live in a nursing home, you have two options to pay for it, either to pay out of pocket or to eventually enroll on Medicaid. Um,
Mm.
and so a trust is a tool. If you put your home or other assets into a particular type of trust, it can shield it from being included as an asset for Medicaid. So you can be impoverished for Medicaid purposes without having to lose all of your assets. Um,
Yes.
and then another group of people, anyone who might have children or other people that they are responsible for who have special needs, almost certainly want to have that kind of trust because while I might not be on Medicaid, for example, I might have a child who is on Medicaid because they were born or had an accident or something that caused them to be unable to work. And if you don't want to leave them an inheritance that now disqualifies them for their medical care.
Right. Yeah.
So it having a special type of trust for that is incredibly helpful. And then also people who have blended families or even a quote unquote complicated situations.
Yes.
Um where it's not like Leave It to Beaver, where mom, dad, two children. If it's more
Pretty
complicated than
obvious
that,
where you want things to go. Yeah,
yeah,
exactly.
exactly. And I'm not, and I have no judgment on people's lifestyles, or whatever. But if you're like, I have wife one, or we moved apart, but I'm now with another person, but we never got divorced, or any number of scenarios that are complicated, um, a trust would be very advantageous to make sure that there's clarity in where things go.
Yeah, exactly. And especially with the blended families where it's like
Mhm.
hers and his and ours kind of
Yep,
situation. Yeah,
exactly. And those situations are so important to have clarity.
absolutely. Um, do you see addictive personality things coming into this as well? Is that another
Oh
scenario?
yes. So if you have like a child, maybe even a spouse, someone who has substance abuse issues, other types of addictions like gambling, shopping, other compulsive behaviors, you don't want to leave them a large sum of money, because otherwise it would lead. I mean, they would, in many ways, probably harm themselves with it. Like I've had clients come in and be like, "My brother has a substance abuse issues, but our parents left him $100,000. What should I do?" And so we're now scour the document looking to see if we can get some kind of trust constructed. And fortunately, most of the time we've been lucky in that one scenario, that brother came in and he agreed to set up a trust where he and his other siblings held the money for him because he
Mm,
recognized that it would be dangerous for him to walk around with a lot of money. Um,
yeah.
but those kind of situations definitely warrant a trust because you want to protect people from themselves. Um, and that and most people would understand why. Even the beneficiary is like, "Oh yeah, I get it, and I appreciate being left that, but not having to hold it."
Yeah. So, how does a trust help us avoid the whole probate situation? I've heard some real nightmares on how long and how expensive that can be.
Oh yes. The upside. So with a will, it has to be presented for probate. So you petition in Georgia anyway. You petition the probate court to say this will is valid, and you should admit it into probate and allow the terms of the will to be followed through. Um, to do that, you have to get the approval of all of their heirs, which would be anyone who would have benefited if there had not been a will, and also
Mm.
acknowledge that there may also be creditors out there who also would receive notice. So
Oh.
if you have a will, for example, that leaves everything to one, if someone has three children and they have a will that leaves everything to two children, that third child might object to the will and create litigation. And it might be good faith litigation, it might not be, but they're kind of playing with house money because they have no incentive to not bog down the
To
process.
not do it,
Yeah.
exactly.
So those kind of issues exist, and also with children, with kids under age of 18, there's a lot of court-appointed guardian ad litems, and it just gets really, really expensive potentially very quickly.
Mhm.
Whereas a trust, because it's a separate document and a separate entity altogether, it does not actually have to go through probate. So in Georgia, if someone dies with assets in a trust, typically the trustee, the person in charge of the trust, typically will wait about 6 months to make sure there are no creditor claims, make sure any final bills are paid. But after that, they can just go ahead and start distributing it right away.
Yeah.
It's akin to like an insurance policy with named beneficiaries where someone passes, the insurance policy says person A, B, and C are the beneficiaries. The insurance policy can cut the checks out right away because they're just following a contract. In the
Right.
same sense as a trustee can distribute because they're not operating under they're operating under something akin to a contract. It's a fiduciary agreement, but nonetheless they can immediately do that without court supervision. In Georgia, some states do have some level of supervision, but it's not nearly as much as this for a will.
I didn't realize that you had to get approval to put a will into probate.
Oh yeah,
That's really interesting.
because you have to file it. You have to file it with the court. They have to make sure that it was correctly executed, and then you have to scrutinize to make sure that the person was of sound mind when they signed it. That the witnesses are available if they didn't sign some forms. So it can be it can be very tedious, but the intent is to make sure that the will is the intention of the deceased person. And unfortunately, the one person you can't ask about the will is the person who's passed. So
Yeah.
you have to go through a very strenuous process to approve a will, whereas a trust has a lighter burden because
Exactly.
it's outside of that. It's in a different area of the code, of the Georgia law book, essentially.
That's interesting, the thing you mentioned about the witnesses being available, because I have a will that I did a long time ago, and my witnesses weren't exactly spring chickens. So
Hopefully, in some ways, they may have signed in Georgia. In most states, allow like an affidavit. The witnesses would sign it for a notary saying that, "Hey, you don't ever need to find me again." But what you see with a lot of older wills is that those forms, that form was not signed, and so I've had times where you have like a 1985 will or something like that, and you're like finding witnesses that hopefully are living, and then if not, you
yeah,
have to certify other people that the signature matches their signature. So you're finding their driver's license and their passports and stuff like that. Like this
right,
signature matches, and eventually the judge will be worn down and be like, if everyone's in agreement, but it's a lot more footwork to do those
right.
things. So yeah.
So I'm kind of getting the feeling that it might be the case that trusts are not just necessary for what we would call wealthy families.
Oh no. In fact, I would say if you're not wealthy, you should definitely consider it because if you're a middle one even if you're wealthy, one way to become less wealthy is to have a probate dispute. So if you are even if you're a middle class, if you're like a regular person, like you definitely want to consider a trust because the cost of a probate dispute can be very, very pricey. If your family has any issues or there's blended or there's lots of I've seen 50, 80, $100,000 probate cases that will definitely eat up an estate. Well, I've seen cases where legal fees after the payment of creditors, the funeral, the headstone, stuff like that, there was like
Yeah.
nothing left in the estate.
Yeah. Oh,
Like the Charles
that's
Dickens
so
Bleak
sad.
House. I'm not sure if I'm
Yeah.
old literature, but at least in my circle, the famous story of an estate that was litigated for so long that the lawyers ended up taking all the money.
Yeah. And that's what we don't want.
That's what you don't want. As much as I like lawyers, I don't think their goal
As
is
much
it's
as we
not a
want
job
you
for
to
the
do
lawyers.
well. Yes,
Yeah,
exactly.
exactly. There's more people I can help. I can make it up in volume.
Exactly. So if somebody already has a will, are they kind of locked in or can they add a trust after that? How
They
does
can
that work?
definitely add a trust. So as long as you are alive and of sound mind, you can update your will and create a trust. And I would definitely say to if you have something and it's especially if it's an older document, like something you got done 10, 15 years ago and things have changed or the situation has changed generally, you should definitely bring in everything you have and talk with an estate planning attorney to update that and see if a trust is a good thing to have as part of your estate plan. Sometimes the trust may be overkill, but you want to hear that from a professional and get their
Yeah.
opinion on it before making that conclusion on your own.
All right. And so, how does what you called a living trust function while the person is still alive?
A typical living trust is it's functionally just like you have full control over the trust. You can modify, amend it. You can do whatever you want with the assets in the trust. So, for example, I if a client puts their house into a trust, they can still sell it. They can still refinance it. They can still do whatever they want. It's more or less invisible to them, but the only times that that trust locks into place and is no longer modifiable is if they're either incapacitated or upon their death. Then whatever the terms they have in the most recent draft of it, the most recent executed copy of it rather, are locked into place. So if you use the last if you started a trust when you were 40, you did 5 amendments to the trust over the next 40 years and then you pass it 80, that last amended version of the trust is now locked into place. So your trustee will then follow that most recent trust to direct your estate.
Okay.
So you can do whatever you want beforehand. So, which I do recommend constantly looking at it, making sure that it continually works for you. And I always tell my clients, if you have a bad Thanksgiving dinner, give me a call. I'll have it updated by Christmas. I've only happened once, and then like, but so just make sure it matches and stuff like that. And actually, that I think it happened that time because someone found it had they're having a new grandbaby, so they were going to add them into their trust. Nothing
Okay, so it was a good reason. It wasn't.
bad.
It
Yeah,
wasn't we're disowning someone.
yeah. No, got the zone yet. I'm open to it. I love a good story, but no, I don't think anyone's figured that out yet.
And what does it mean to fund a trust? Does this mean you have to have a pile of money sitting around?
So the fund the trust, so that does means to transfer things into the trust. So for a house that might be deeding it into the trust, for money that often involves either setting up a trust bank account, or if you have a personal bank account, you may want to add the trust as a payable on death beneficiary to it. Um,
Okay.
and so that upon one's death, the bank account automatically transfers into the trust. Same for stuff like life insurance. Either you want to change the ownership of the life insurance to the trust, or the simpler thing for most people is to at least add the trust as the death beneficiary of the life insurance policy. Anything you want to go into the trust, you have to overtly either title it to the trust or have it be designated as a beneficiary so that it then goes into the trust. So the
All
idea
right.
is that anything that's in the name of the trust gets distributed according to the trust, but everything that you leave in your own name has to be distributed according to the will. Um,
Right.
and so the
Got it.
backup thing is called a pour over will. So if you have a trust, often your attorney will create what's called a pour over will, which is a will essentially is a new will that says, hey, this will, the sole beneficiary of this will is my trust. So that if for any reason I forgot to put something in my trust, or I acquired something after funding my trust, that it then gets directed into the trust. But that's more of a breaking case of fire situation. But you do want to make sure
Okay.
everything has a route to get into your trust if you want
Very
it to be
good.
follow those directions in that trust.
Thank you. That's been very informative information.
Oh, thank you.
So that's it for today's conversation. To connect with Stephen or learn more about estate and family law in Georgia, head to scriberlaw.com. If you found this helpful, take a moment to subscribe, leave a review, and share the show with someone who could use clear, trustworthy legal advice. We'll be back with more real world advice to help you plan ahead, protect your loved ones, and move forward with confidence in the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.